IVM.
Welcome to All Things Policy, a daily podcast supported by Pragati, a flagship media initiative of the Takshashila Institution. We're a bunch of policy nerds based in Bengaluru, and we like to bring a fresh perspective to Indian affairs and an Indian perspective to global affairs. So grab a cup of coffee, sit back, and join us for today's chat.
Hello and welcome to All Things Policy. I'm your host, Shrikrishna Upadhyaya, and today we're going to be talking about the significant decision handed down by the Supreme Court of India yesterday concerning same-sex marriages. By a majority, the Supreme Court of India held that there is no fundamental right to marry and refused to grant legal recognition for same-sex marriages in the country. To talk about this issue today, I have with me research analyst Takshashila and my colleague Saurabh Todi on the show. Saurabh, welcome to All Things Policy.
Thank you, Shri. Happy to be here.
Right. I will begin this discussion by setting the context on the Supreme Court judgment. This was given by a 5-judge bench known as the Constitutional Bench. There were 4 judgments in total. Just to sort of ensure that we are on the same page and all the listeners can have benefit of, what the judges spoke about, I'll quickly take a few minutes and summarize the judgment for all of you. So let's understand this, right? There were 3 prominent issues which the Supreme Court gave an answer to, and there were 4 judgments. So one judgment was by the Chief Justice of India, D.Y. Chandrachud. The second judgment was by Justice Kaul, who more or less agreed with what Chandrachud said. The third judgment was by Justice Bhatt, and Justice Kohli joined Justice Bhatt's opinion. And the fourth judgment was by Justice Narasimha. We can actually sort of discern majority on certain issues between these judges. In fact, on one of the issues, there is a complete majority, which is on the fundamental right to marry, where all the judges said that there is no fundamental right to marry, but it is just a fundamental freedom for people to exercise. But on many other issues, there is a 3-2 split, with the Chief Justice and Justice Kaul on forming the minority, while Justice Bhatt and Justice Narasimha's opinion forming the majority. So to quickly look at these 3 issues of fundamental right to marry, whether Special Marriage Act can be read in a way to recognize same-sex marriages, and whether the queer people have a right to civil union. So on the first question, like I mentioned earlier, all the 5 judges agreed that there is no fundamental right to marry, because declaring the right to marry a fundamental right would create an obligation upon the state, which the court could not do. On the second question, whether the Special Marriage Act, which is actually a law enacted in 1954 to enable intercaste and interreligious marriages, which faced a lot of social opposition back then and continue to do so, whether this act can include same-sex marriages. This was one of the positions, which was one of the questions that the court examined. However, over this, there was also an agreement among the judges that, they cannot read the statute in a way to include the right of queer people to marry under the Special Marriage Act. Now, typically when a court exercises its powers of judicial review and does legal interpretation, it can read down or read up statutes to save it from unconstitutionality, right? So one of the options for the court was reading, of course, declaring that non-inclusion of homosexual marriages in the Special Marriage Act was discrimination and violation of Article 15. And to save the constitutionality of the statute, they could have said that the provisions in SMA should include same-sex marriages. But the court said this is not an exercise they want to carry out. They said there are multiple interpretive difficulties when it comes to SMA, and any sort of rereading of the Special Marriage Act might impinge upon the rights of women and other categories which are protected under the law. Now, the third question, which is interesting, and Saurabh, I want to hear more from you on this aspect as well, was whether the court could recognize the right to a civil union for queer people, right? However, the Supreme Court refused this as well. The judges held that, the state, although the people have a fundamental right to choose their partner and live with them without being disturbed by the state, police, other authorities, societies and all, but they could not actually grant a legal recognition for this sort of a union between people. If at all the court had taken this route of guaranteeing the right to civil union, then they could have compelled the state to come up with a legislative framework for enabling and protecting the rights of same-sex couples. But even on this issue, the petitioners lost, and the court ultimately held that it cannot force the state to recognize civil unions. So I'll stop here. And Saurabh, on the 3 issues that I mentioned broadly, which is about the fundamental right to marry, the interpretive issues around the Special Marriage Act, as well as the right to civil union, I want to hear your broad thoughts. What is your opinion on this?
So, Shri, obviously this was a very significant judgment, right? It really kind of highlights the kind of struggle that the community is going to have to kind of do for years and years to come, because the rights that they thought that would be granted, even if in a limited fashion did not happen yesterday. But I am not a legal expert, so I will refrain from, commenting on the specifics of the judgment, whether, there is a right to marry or not. But I would say in the question of civil unions, I am curious because there seems to be an agreement between all the 5 judges that discrimination against the LGBT community is not acceptable. And they ought to have the rights that, further their life in a dignified manner. So there was an agreement on this, and the minority opinion of the Chief Justice kind of laid out almost all the legal rationale for why, all the rights to property, rights to being able to, open joint bank accounts, or, being part as a nominee for PF, and all of these instruments, these small things which, add up to a very significant measure of what it means to be married. So this was there, but it was quite perplexing that on one hand, the judges agreed that these rights, or these are all these rights are important to live with dignity, but they did not provide any remedy to ensure that these rights are protected. So, for example, they did recognize that the government has kind of committed that they will set up a committee under the cabinet secretary to kind of figure out what kind of civil rights can be given short of marriage to same-sex couples. So that is fine, but I think the bare minimum that the court should have done was to recognize that even if marriage is a bridge too far, a legal recognition of same-sex couples in a civil union was essential, absolutely required to safeguard these rights that the court has already agreed that are important. And then you could have left that to the wisdom of the executive or the parliament to decide what exactly those rights are, how will they be enforced, what are the remedies. Right now, what we have is that we have taken the government, the executive at face value. And as we have seen that this issue is not something that is very pressing for anyone in the parliament or in the government. Even this commitment came up during the hearings because, to kind of show that, okay, we are concerned about this. But it is quite possible that this kind of committee idea would be put in the cold storage. So it's disappointing, but I would say that the bare minimum should have been that you gave a legal recognition to the right to have a lawfully recognized relationship. And then you could have still not transgressed into the domain of parliament and made what exactly those rights would be. But it's a missed opportunity, to be honest.
Right. Like you pointed out, I think the majority opinion of Justice Budd uses an analogy, which I would like to contest. He says that, there is a fundamental right to move across the territory of India, but this does not mean there is a positive obligation upon the government to build roads wherever you want to go. And he uses this sort of analogy to explain the fact that, you can claim that there is a right, but whether there exists a positive obligation for the state to enable the fulfillment of that right, now that's a separate issue altogether. But I would like to say here, the distinction here is there already exists a road for heterosexuals. The denial and the discrimination comes when you're not letting the homosexual or the same-sex queer people enter the road, right? So that is a sort of discrimination which is being contested by the petitioners in this case. Having said that, in terms of remedies, like you rightly pointed out, our courts have not been shy of recognizing new rights as part of our fundamental rights, whether under Article 14, 19 or 21, which talks about equality, fundamental freedom, right to life and so on. And also ensuring that or nudging or sort of propelling the state towards recognition of these rights. I can give you 2 examples which come to my mind. One is, of course, in the Puttaswamy judgment, a 9-judge bench of the Supreme Court, when it held that there is fundamental right to privacy, which includes data protection of individuals. They declared that right. And then they said that the parliament can now enact a comprehensive data protection legislation, which the parliament did many, many years later after a lot of struggle. But the parliament still did it. The second instance that I can think of is with regard to euthanasia, right? The Supreme Court actually said that passive euthanasia is a part of your fundamental right to die with dignity, which is part of Article 21, and gave a series of guidelines to effectuate this right and make it a reality. So now taking a step back and zooming out a bit. So whenever a question like this comes before the court, broadly speaking, there are 2 kinds of remedies that the court can fashion, right? One of the remedies is called an injunction. The second is called a declaration. Now, injunction is when you compel the state to perform a certain act or restrain the state from performing any act and violating a fundamental right. That here in this case might have been a little difficult, given that this issue is not simply a violation of fundamental right, but it is a classic case of under-inclusion, where the rights of certain people do not find recognition in the law. The second thing which I feel the court could have done is to issue a declaratory remedy, which I think you also spoke about, right? That declared that there is a right to civil union, if not marriage, and let the state work out the specific. Let the parliament legislate, or the executive through its act ensure that these rights which are declared as fundamental are in fact implemented and enforced. So this is a path which, like you pointed out, was available for the court, but however it chose not to do it. So I want to hear your thoughts on this kind of decision which could have come from the court, and also on the larger issue of judicial activism, because I know that you are a critic of judicial activism. But here, did you think that the court was lacking in its own activism, which is formed on the basis of its precedents?
Yeah, so I think it is a well-known fact that, the Supreme Court, or in India, judiciary in general, is quite like the separation of powers is not really a thing. It depends on what the issue is being discussed, debated, or in front of the courts. Courts have really frequently transgressed into the domain of both executive and legislature, and have exceeded the briefs of what is expected out of the judiciary. So having said that, I think it was a welcome development to see that the Supreme Court was refrained itself from transgressing into the domain of both executive and the legislature, where, for example, if there were more than 150 laws that would have had to be amended to kind of allow for the same-sex marriage to be legally recognized, I think that certainly comes under the domain of both the executive and then the parliament. However, I think what is curious is that if this judgment was like the starting point of a scaled back judiciary, where now they're going to kind of refrain from doing this in every case, then I guess that's a welcome development. And although this is unfortunate for the community, but I think for the greater health of the democracy and the separation of powers doctrine, I think this is a welcome move. But I don't think that's the case. I mean, we'll see that in a few days, when we have more other contentious judgments, is that it seems like the court just chose an easy way out. It hid behind this cloak of, we can't transgress, when, as you rightly pointed out, there are other remedies short of actually transgressing into the domain, which was, again, just giving a declaration would have been kind of enough of a nudge for the government to do something about it. You could have both safeguarded the rights of the LGBT community while ensuring that you did not exceed your brief. But the Supreme Court did not do that. And so if this is a starting point of something like a more restrained court, I'm all for it. But I have almost zero hope that that is the case. I think this was just an easy way out for the court to not kind of declare something that might be seen as contentious. And it's quite unfortunate.
Right. And like you said, even I have my reservations as to whether this kind of restraint will be practiced in the coming cases, because, the Supreme Court operates in benches and it decides matters one by one. So in every different matter, it takes its own course. Consistency is one thing which is definitely lacking. But having said that, it is important to remember that, like we say in public policy, that never judge a policy by its intentions, but by its outcomes. So similarly, when we are judging a judgment of a court, never judge the judgment by the rhetoric that the court speaks, but judge it by the remedy or the actual outcome or the relief which the court provides the petitioners, right? Because that is where the crucial reason as to why a person approaches a court gets satisfied. What is the relief that you get from the court ultimately? Because our Supreme Court, or even high courts for that matter, like verbose prose, and they speak tons and tons of words. But what is the actual remedy that has been granted to the petitioner is what something that we need to focus on. So let's look at Justice Bhatt and Justice Chandrachud's opinion, because these are the two judges who are given some sort of remedies to the queer couple. And I think the most important one, of course, is taking on the statement given by the Solicitor General that the government is willing to constitute a high-powered committee set up by the Union Cabinet Secretary to comprehensively examine all the issues that are involved and ensure that certain kind of legal entitlements can be extended to queer couples also. Now, the court has made this assurance given by the solicitor absolute. It has said that the government is duty-bound to constitute this committee. And for instance, the court looks at certain items which these committees can be looked at. Right now, Justice Bhatt mentions employment benefits, provident fund, gratuity, family pension, employee state insurance, medical insurance, material entitlements unconnected with matrimonial matters, etc. These are some of the things which this committee can look at and come up with the policy policy which all the state governments and the central government will be required to follow. Only Justice Chandrachud actually goes a step ahead and lays down concrete terms of reference, which I think the majority opinion of Justice Bhatt failed to do so. And Justice Chandrachud, for example, in his terms of reference for the committee, talks of ration cards, joint bank accounts, the right to name a partner as a nominee in case of death, the duty of medical practitioners to consult family or next kin, extending this to queer couples, jail visitation rights, the right to access the body of the deceased partners and arrange the last rites, legal consequences such as succession rights, maintenance, financial benefits under the Income Tax Act, rights flowing from gratuity, family pensions and insurance. He mentions all these items as the terms of reference that the committee should look at. However, the court fails on two aspects. I think both the majority and the minority fails on two aspects. One is setting down a concrete timeline for this committee, right? There is nothing on that. Second aspect, in which, in fact, I can think of three. The second aspect is, of course, looking at the composition of the committee. Now, is this going to be a purely administrative committee headed by bureaucrats? Although the court makes references, says that, you should be a diverse committee, you should have domain experts, you should have representatives from the community and so on. But there is nothing which is strictly worded to force the government's hand, right? And the third thing and the final thing which I feel the court should have done was to keep the matter open, right, rather than leave it at this. So now what the court says, it ends, at least Justice Chandrachud ends by saying that, the report of this committee shall be implemented by all the concerned government authorities. Why do that, right? Because that sort of puts a finality to the matter. If the court is really concerned about queer rights, which it seems to be looking at all the rhetoric that it has handed out, the court could have kept the matter open, say post the matter after 6 months and look at the recommendations of the committee, or at least the work that the committee has been doing. So I think these 2-3 aspects were missed opportunities as far as this committee remedy, which ultimately the petitioner received from the court. So I want to hear your thoughts on this, Saurabh.
Yeah, so I mean, see, the Chief Justice has really laid down very comprehensively, right? Like, what are the different things that rights and issues that should be considered when this committee will meet to decide, what. But I think even at the same time, the committee may well decide that all of these are not needed. Right. It is like there is no obligation that because the Supreme Court did not give a declaration that these rights must be respected and upheld for same-sex couples as well, the committee may well say, oh, we don't need that, it's fine the way things are going, and that's the end of it. But if the court would have given is the fact that you have to protect these rights and you have to consider how to ensure that same-sex couples have the right to all of these things, and then the committee would have tried to figure out how to implement those. So I think it is like a lot of fluff, and as you said that like in the starting of the hearing also, it was such great eloquent speeches for everything, but even like the consensus judgment actually gives nothing. Like, it gives zero things to the community. It just says very normal benign things that, okay, you should respect the rights, there should be no discrimination, etc., etc. That is there already. Yeah. And how do you enforce that? Like, there is no mechanism to enforce. And so it again goes back to the problem, right? That we have like a lot of eloquence speeches, but the judgment ends up being very, very short of, what it should have done, or at least could do at the bare minimum. So I guess right now the community is more or less at the mercy of the government if and when they decide to constitute this committee. I mean, anyways, the elections are due in less than a year. So I don't think that this is something that is of importance to the government or anyone, to be very honest. I mean, no party, no government, no state, even during the hearings was even remotely interested in tackling this issue. Some states did say that there is a need for more robust discussions, but I don't see that happening. But I'm curious actually, Shri, that given that marriage is in the concurrent list, is there a possibility, or at least in theory, can some states decide to recognize civil unions, at least if not marriage, in their own states and start the process? Or what's the background for that?
Stay tuned to All Things Policy. We'll be right back after a short commercial break. Yeah, this is an interesting question because I think I saw one of the headlines in some news outlet which said that, the court has held that the states are free to legislate on this issue if they want to. But let's keep few things in mind. One, I think we have had this discussion earlier also when the union government said let's make state governments also party to the petition in the Supreme Court. I think almost all state governments opposed it, right? So I don't think politically this is a very feasible thing. So why would any elected government put their sort of political will behind this sort of issue? Having said that, now as things stand, marriage is of course a part of your concurrent list. So both the union as well as the states can legislate on this subject matter. However, right now we have almost all laws on marriage, divorce, adoption, succession, etc. made by the union government, made by the parliament, which hold the field, right? So when there is a union law holding the field, the state government cannot make a law which contradicts the provisions of the union law. And if they want to make it, they will have to take precedent's approval, right? So this is the crux of the matter. So if tomorrow a state wants to, for example, include same-sex couples within marriage laws or adoption laws, they will require the president's approval, right? Which again, I don't see it forthcoming. The other aspect of this is like you pointed out, can states go ahead and recognize civil unions, right? Can, for example, the government of Karnataka or Maharashtra make a law called the Right of Same-Sex Couple to Civil Unions Act? Can they do that? Now, I don't think there's anything which forbids the states from doing it. I think they can very well do it, but there will be an interpretive issue. Then the question would be, what is the entry in your concurrent list or the state list under which the state is making such a law, right? The state will have to justify its legislative competence on this account. Now, would you again rely on an entry like marriage? Would the union then come and argue that no, this is a domain which we have already made laws on this, the states cannot make a law on this aspect? So I don't know how that is going to pan out, but the first point remains, which is that there is no political will even at the state level to ensure this happens. I think a more feasible thing which state governments can do, at least some of them which believe this issue needs a quick resolution, is that set up their own committees at the state level to identify aspects which come under the state government's domain, which can again be extended to same-sex or queer couples, right? For example, ration cards. Ration cards are a state subject. State governments issue them. So I don't see why a state government cannot start issuing ration cards to same-sex couples, right? Or for example, in state pension schemes or insurance schemes, why they cannot extend the same right to queer couples. So that's my take on this. What do you think?
Yeah, that makes sense. I was looking at, okay, if somebody, hypothetically is interested, like some state or some party, then can they do it? And I'm with you. I don't think any party really cares about this or even has the will to go ahead with this. Even with, I think that idea that, okay, at least at the state level, you can form these committees and they figure out, what are the remedies that states can do. But even in that case, for example, I think I'm thinking of, in terms of actual kind of, I don't think it will work in the sense that even if you want to say that you want to give a ration card to a same-sex couple, what is the proof that they're a couple, right? So you come back to the point that you have to recognize that union. Some way you have to say that, okay, these two individuals are connected and are not just two random individuals. So that again comes back to the point that you have to somehow say that these two individuals are connected. And on the basis of that connection, you are being given a ration card or pension scheme or stuff like that. And I mean, the reason I also said this was that I think this issue is not partisan. Like no government, no party, no state is really in favor of this. They may be opposed or they may say that we need more discussions, but no party, no state government has come out in open officially to support this. There have been private members' bills in the parliament, but that is also very rare, and they obviously have no chance of passing. So one of the reasons why I was asking this is that people sometimes think that this issue is partisan, or it is because, if you have the change of government or change of party or change of, change of bureaucrats or whatever, it has broad consensus that this is not something that they care about. So that is why I think the idea was the Supreme Court would provide at least a direction so that the governments who are ambivalent will be like, okay, you know what? Let's do this because we were told to do this by the Supreme Court. So so I would say that there are a lot of opportunities and a lot of parties, individuals, politicians who are progressive can technically push for these reforms at the state level. But I don't think that's going to happen because there's a lot of, again, rhetoric, but very less or at least non-existent substance in these efforts.
Right. But at the same time, Saurabh, I also think we need to keep in mind some positives that may spill out from this judgment, right? One is, of course, this judgment, all the 5 judges unambiguously have reaffirmed that trans persons have the right to marry under their respective personal laws or the Special Marriage Act, which is welcome. Of course, this is not new. This right at least existed since the Nalsa judgment of Supreme Court in 2013, which gave legal recognition to transgenders, and as well as the Trans Rights Act, which came, I think, somewhere in 2017, if I'm not wrong, which was passed by the parliament. So trans people can marry as heterosexual couples, which is important and welcome. And the court has reaffirmed this right. All the 5 judges have. So it's a solid precedent which has been set. The second thing is, I think there is enough in the judgment which will come to the aid of lawyers and litigants seeking reliefs across various high courts and maybe even in the Supreme Court in the coming years. Because let's face it, our society still does not accept homosexual couples, queer couples. We often see media reports where queer couples approach high courts for police protection because they are being coerced or persecuted by their family members or society members. So in such situations, I'm sure the language of the Supreme Court in this judgment, where they have clearly said that any form of discrimination and violence against homosexual couples or same-sex couples is unacceptable, and the state must protect the right of these people to live together and choose a partner of their choice. So I'm sure this will come in aid of lawyers and litigants across the country who are fighting for these rights at a ground level, seeking police protection in high courts and so on. So to that extent, I do feel this judgment has tremendous value for litigants. So what are your thoughts on this, Saurabh?
Yeah, I agree. I mean, I think we have been a bit pessimistic since the start of this podcast. I mean, I think one kind of a very big positive here is that, first of all, there has been now more visibility of this issue in the public in general and even within courts, lawyers, and the legal community. And I think the same goes for even faith in the government. That's one. Second, I would also say that I think it's also important that the Supreme Court did not say that the same-sex couples don't have the right to marriage, right? They just said that there is no fundamental right to marriage through which you can maybe insert this into the Special Marriage Act or some other statute. So if the parliament wants, if the executive so desires, they can create frameworks and laws in which they can provide this remedy to same-sex couples. So in that case, I think there is no legal bar into saying that, in many countries we have this, there are rules, laws and regulations, even judgments saying that same-sex marriage is illegal. That is not legal. So there is a negative kind of
implication to it.
Yeah. So you being in that union will kind of lead to fines or jail time or whatever. In India, either it is just benign with no legal, civil or criminal consequence, or you at least allow the governments to make laws on this. So I think that is a big plus. And also I think all the fact that Supreme Court has reformed that queer individuals are discriminated, and so there should be remedies that they are not done that. I mean, although they do fall short of giving those remedies, but the fact is that they recognize that this problem exists and that needs to be addressed. So I mean, those things are quite positive, and I guess that, as you said, this would kind of then lead to lawyers and civil society to advocate for more, I guess, specific laws and regulations to be then amended. So it's a long process. I'm guessing that now the fight would be on specific provisions, which I think will fall short of marriage, but I think would at least lead to giving rights to same-sex couples, even though piecemeal, but it's a welcome start.
Right. So thanks a lot, Saurabh, for joining me on this conversation today. And like you said, it's a long road ahead. A piecemeal approach is probably what the queer right activists and queer people have to follow in the coming years. But let's look at the outcomes of this committee whenever it is set up. And I'd be happy to speak about this again whenever the time comes with you. Thanks once again for joining All Things Policy.
Thank you, Shri. Happy to be here.
If you liked our show, don't forget to check out other interesting podcasts on the IVM network. You can tune into them on the IVM Podcast app, ivmpodcast.com, or wherever you listen to your podcasts. You can also follow IVM on social media. The handle is @IVM Podcasts on Twitter, Facebook, and Instagram. And hey, if you'd like to dive into Takshashila's research on technology, strategy, and economic affairs, check us out at our Twitter handle @TakshashilaINST or our website takshashila.org.in.